Hey everybody, it's me again, State Planning Attorney Paul Rabelais. Got a lot of information to share. Let's just jump right in. All right, here we go. What makes a will valid or invalid in Louisiana? So this is going to be a pretty short one. A lot of my live streams, they go on and on. They go on for 30, 45 minutes. This one's going to be pretty quick. It's really limited just to what makes a will valid and what makes a will invalid. And we're going to focus on the state of Louisiana. Every state has their own rules on what makes a will valid or invalid. So that's what we're going to hit. Let's jump right in. First of all, what's all the fuss about whether it's valid or not? Well, you probably already know why all the fuss. For some people, a will is maybe the most important thing that they ever sign. They spent a lifetime accumulating things, bank accounts, houses, businesses, and the will is, as long as they keep those assets in their name, their will is that instrument that disposes of all of those assets to their desired heirs. And so if you mess it up, then and a will is invalid, then the state's going to determine who gets your stuff. If someone does have a will controls who inherits from them. Someone doesn't have a will, state laws, or we refer to them as the intestate laws. Every state has laws on its books. The body of state makers has put out some rules on who inherits from you if you die without a will. All right, a couple of things before we really jump into it. What's valid or not is we'll do another one on what makes a valid trust, because I feel like I at least need to mention some people leave assets to their survivors through their will. Other people and attempt to avoid the court and attorney involved probate process. They create their living trust, transfer assets to their trust. Their will oftentimes becomes irrelevant. Their will is never used because their trust controls the disposition of those trust assets when they pass away. So we're not going to go into the trust stuff this evening. I'll do another live stream on what makes a valid trust and why people do all that. I've made many of them. But this is really focused on the will because some people do leave their estates behind to their survivors through their will. All right, let's jump right in. Talking about some of the Louisiana specifics. Don't see a lot of that on social media, YouTube, so let's jump right in. First of all, I need to, let's see, I'm going to need to point out a couple of things. Let me move some things around here on my screen. Point out a couple of things. Let me show my screen. All right, so let's jump in. And I'm going to show you the statutes that define everything, so you won't have to take my word for it. In Louisiana, like it says on the screen, there are two forms. A testament is another word for a will. There are two forms of testaments in Louisiana. One is called an olographic testament, not as common. The other is called a notarial testament, very common. All right, so let's jump into that. Those are the only two kinds of wills that are recognized as valid wills in Louisiana. So we're going to look at one, what are the requirements or what is an olographic testament? And then two, what is a notarial testament? First, let's jump into the olographic, not used as much, but is used sometimes. So the statute here that defines what an olographic testament is. Keywords here. It's one entirely written, dated, and signed in the handwriting of the testator. A lot of mistakes get made there. Sometimes daughter may write out some things and then mom signs it at the end. Not a valid olographic testament. Got to be entirely written and dated, signed in mom's handwriting if mom's the one writing the will. Sometimes you'll see people type some stuff up and then mom signs it at the end. And doesn't count, doesn't cut it. It's not a valid olographic testament. Although the date may appear anywhere in the testament, the testator must sign the testament at the end of the testament. So all in the testator's handwriting, gotta have that signature at the end. You don't have it, not a valid olographic testament. Don't give anybody the opportunity to challenge the will because you didn't follow the statute by the letter. If anything is written by the testator after his signature, the testament shall not be invalid, and such writing may be considered by the court in its discretion as part of the testament. So again, here we go. If you're going, don't sign it and then write stuff at the end. Now you're giving a judge an opportunity to invalidate the will because the statute gives a judge discretion. All right. Let's see. The Olographic testament is subject to no other requirement as to form. The date is sufficiently indicated if the day, month, and year reasonably. So you gotta date it. Some people write out the date, which is not a bad idea. Write out the word August. Some people, like to use the numbers, and then are you putting the month first or the day first and all that. So just don't get real cute with your date. And then it says additions and deletions on the testament may begin effect only if made by the hand of the testator. I kind of feel like, boy, if you're going to change your olographic will, just start over and write a new one. So how do people do it? People do their olographic wills by just pulling out a sheet of paper or a legal pad, and they just start writing away. All right, here's the problem with olographic wills. It's pretty easy to meet this requirement of a valid olographic will. That's the easy part, is meeting the validity requirement. The part that's a little more challenging is putting the appropriate wording in there so that you cover everything that you need to cover. It's not ambiguous. You make all of the appointments that you need to make in a will. You're clear as to who your heirs are and what they inherited. Are they inheriting specific assets? Are they what we call a residuary legatee, where they're just getting kind of what's left after the specific bequests are created? What if people that you name in your will pass away before you? So I've seen some people write olographic wills, leave everything to their spouse. They die 15 years later, but their spouse has already passed away. So again, the easy part, pretty easy to create an olographic testament. So easy to meet the validity requirements, just hard to make sure your legal wording is correct. I think the most famous olographic testament, and look, by the way, I think it's around 26, 27 states permit these olographic or holographic testaments entirely in the handwriting of the testator. Doesn't need to be notarized, doesn't need to be witnessed. Do you see any kind of notary or witness requirement in the statute? No, you don't, because I suppose the lawmakers in our state wanted to make it easy for people to create a will, so they enable people to make these olographic testaments. These are, I'd say, of every 100 wills created in Louisiana, I'd have to guess that 98 or 99 are not olographic testaments, which means out of every 100 wills that are written, maybe one is olographic because somebody tried to do it themselves. And of those olographic testaments that were created, there's maybe problems with half of them once the testator dies. Okay, but nonetheless, it's one of our forms of a valid will. Now we got to go into a second form of a valid will, and it's what's called a notarial testament. So let's pop that up and look at what those requirements are. So these very common. And so a notarial testament, that's when you go to the attorney guides you through the decisions that you need to be guided through. The attorney prepares the testament, the notarial testament. You come in and sign and meet all of the validity requirements. So let's look at what the requirements are for a notarial testament. Shall be prepared in writing and dated. It says in writing, it's typically typed up, by the attorney and dated, and shall be executed in the following manner. If the testator knows how to sign his name and to read and is physically able to do both, which is the case for most people who do their will, they know how to sign their name and they know how to read. So if they know how to sign their name and to read, and they're physically able to do both, which happens most of the time, then two things have to be met. One, in the presence of a notary, and two, competent witnesses. The testator, that's the person whose will it is, shall declare or signify to them that the instrument is his testament, and shall sign his name at the end of the testament and on each other separate page. Okay, so a couple of things there that got to be met. Got to declare or signify that the instrument is their testament, and it's in the presence of a notary and two competent witnesses. And the testator has to sign his name at the end of the testament and on each other separate page. Many notarial testaments are 5 pages long, 15 pages long, And so very clear, to make it a valid notarial testament must be signed at the end of the testament and on each other separate page. So it doesn't just say sign it at the end. And I know many states in our country, their will laws say the testator must sign it at the end. Louisiana signed at the end of the testament and on each other separate page. Second requirement for a notarial testament: in the presence of the testator and each other, the notary and the witnesses shall sign the following declaration or one substantially similar. We typically call this the attestation clause. There's no reason to deviate from this. Why in the world would you want to deviate from this? You have to sign that these words have to be in the will or something substantially similar. Don't take the chance that that what's in there is not substantially similar. So use these words: in our presence, blah, blah, blah. You see it on the screen. Testator has declared or signified that is this testament signed on the blah, 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 blah. Okay, and the date. So no reason for that attestation clause in that notarial testament to say anything other than just what's in the statute there. And then, of course, it's signed at the end. Of course, it's signed on every page, as we already realized it had to be. And we realized it's signed on the end. And when it's signed at the end, then it's done in the presence of a notary and two witnesses. They also sign as a notary, and the two witnesses sign as witnesses. And as long, as that attestation clause is there, then the will is valid. We're not getting into the wording of the will and what words you should use to make your bequests. We're just trying to meet that low bar for purposes of this live stream as to what is a will and what's valid and what's not. Okay, and then there's other notarial testament requirements when there's different requirements when somebody's not able to sign or not able to read. There's Braille notarial testaments. I've never done one in 30-something years. I'm sure some people have. I just haven't. I've done thousands and thousands of wills, just never done a notarial testament in Braille form. And then we've got a statute for deaf or deaf and blind notarial testament and the form and the witnesses and what's required there. But I'm not going to get into that because those are so unusual. All right. So what are maybe some of the mistakes that people make when they try to make their wills valid, but they mess it up? Well, typically the biggest problem is they don't meet these validity requirements. If it's an olographic testament, it's not entirely in the handwriting of the testator. It's not signed at the end. Somebody typed something up. Somebody else wrote it. And I've seen a lot of people attempt to make an olographic will, and then they go bring it to a notary and have some notary notarize it. There is no notary requirement for an olographic testament. So if you're making an olographic testament, which very few people do, there is no need, don't go to the grocery store or the UPS store or wherever and attempt to get it notarized. It's not going to make it any more valid. The other issue, the mistake we've seen many times over the years with notarial testaments is people don't sign every page. And I don't know why. The statute is clear. Maybe it's because the people who are guiding them through that notarial testament don't know better. Maybe it's because other states don't require that every page be signed. Other mistakes we see are the attestation clause is not included. Ought to be there, says so in the statute, or the attestation clause is not substantially similar to the one in the statute. Doesn't make any sense to me why anyone would do that. Got the words right there in the statute. All you got to do is copy those words and paste it into your will to meet that requirement of the attestation clause. So that's it. Just making sure that you understand the validity requirements, and because really messing that up, oh boy, it can really affect families perhaps for generations. Okay, hope that